let's go ahead and get started. Hello, I'm Derek Jensen. Welcome to Jensen Estate Law's presentation of the Washington Estate Tax, from death planning to life planning. Today, we're really going to be looking at understanding the 2025 changes, shifting from a death planning mindset to a life planning mindset, and the foundation package of the kind of planning that we want to make sure that all people have here in the state of Washington. We're going to also look at some of the unique gifting strategies that we've developed here over the last 4 or 5 months as we prepared for this tax law change. One of those techniques that's very popular at the federal level is the slats, and so we're going to run through that with you. And we'll also be talking about maintaining your residence here in Washington, not having to leave Washington. That's our goal, is to have you be able to stay here and not be leaving the state because of that. I've also have an opportunity to share with you our Washington estate tax calculator, which you can use on your own to calculate what your estate tax liability would be. And so we'll be sharing that with you and also answering some questions. I'm going to be pretty lively here in the conversation today. There's a lot to cover and there's a lot of extra details. We'll have to come back to this in the future as we kind of progress through time here. But for now, let's go ahead and look at really understanding the 2025 Washington State estate tax changes. These went into effect as of the 1st of July. The bill was presented and passed through the Senate and the House, and then presented to the governor for signature, and became effective as of the 1st of July. So what's going on here? Let's look at the history of the Washington estate tax. So we've had the Washington estate tax, but there was really a decoupling that happened from the federal estate tax in 2025. And at that point, Washington started to collect its own estate taxes due to that decoupling. And that had to do with what was going on at the federal level. The Washington exemption has been frozen since 2018. It was set to index for inflation, but the indexing stopped. And so we've had this problem developing where people's estates had been growing and had not really had to worry about estate taxes in the past. But now with that exemption frozen in time at the 2018 level and having the higher inflation over the last few years, people were seeing themselves suddenly pulled into an estate tax. And that was never really the intent of the Washington estate tax. It was supposed to index for inflation. So one of the things that the Washington legislature took up in 2025 was, how can we fix that? How can we fix this kind of inequity that was happening due to really a deficiency in the prior legislation? And so they raised the exemption up to $3 million. Instead of trying to go back and calculate where it would have been, they just said, let's set it at $3 million. And they turned back on indexing. So we will have indexing continuing in the future. And that's important for anyone who has a taxable state here in Washington. But of course, whenever there is a tax cut, which this really is, they're going to look for additional revenue someplace. And so what happened there was we did see an increase in those Washington estate tax rates, and with the top rate going from 20% up to 35%. And that's created a lot of stir and controversy. It actually ends up being a higher amount than would be paid to the federal government when we calculate in the deductibility of the Washington exemption when calculating the federal tax. So it really is a motivator then for folks, that 35% bracket. However, for states that are more that are under around $9 million, you will actually be seeing a tax cut, which is fabulous for those folks. But those tax rates do go up after that. So this put a new emphasis at the state level for doing planning here and for looking at this. And that, again, I think there's some frightening impact of that 35% bracket. and thinking about, well, hey, maybe I should just leave the state. And we're going to try to address that and allow you to plan without having to move out of the estate here. So what happened here with those brackets? Well, here's an example of what the old law had been and really what the new law is now. And so we're seeing those exemptions and where they were at and the newer rates kick in. And so you can see that once you have an estate that is, $3 to $4 million taxable, we're starting to see that pick up speed. And we're seeing that those last 3 or 4 brackets are really significantly higher than what their predecessor rates had been. And so this is what's catching people here. Kind of looking at this and how does this compare in with the federal system? First of all, the federal government was also, we were looking at potentially a phase out of the prior estate tax law. And so we were going to be seeing maybe a sunset happening here and going down to a lower number than our current $13.99 million at the federal level. And instead, the budget bill, which passed either on the 3rd or 4th of July, ended up giving us a $15 million exemption next year and making that federal exemption permanent. Permanent, that is, until Congress decides to change it. So with Washington state exposure, we do see that we're going to be paying Washington estate taxes long before we're going to be paying federal estate taxes. And again, I mentioned it earlier, but the combined rates then of these two, when you start to add them together, we do get the deduction for the state tax paid on the federal return, but that does bring us to about a 61%. So 60% here's what we've listed, but the actual calculation would be at 61% for the highest marginal dollar if you were in the top brackets on both. So understanding the interplay of the federal government tax law and the state of Washington tax law really shows us where we do have opportunities to do planning for folks and help them address those federal estate tax issues. So as we are looking forward here, one of the concepts that I want to express and believe is necessary is to start to shift our mindset from estate tax planning just being planning that's done at the time of death. Really, in order to take advantage of the Washington law, we need to be considering lifetime gifting. And the reason is that lifetime gifts are not taxed by the state of Washington. So in addition to your $3 million exemption at the time of your death, you also have the ability to gift whatever amount you can gift tax-free under the federal law. And so that could be using next year your $15 million exemption, plus those annual exclusion gifts that you may be giving. So there's a significant opportunity to gift assets out of your estate, and also by doing that, avoid the Washington estate tax. So imagine, for example, that you do have a $10 million estate and your estate is being taxed at the highest Washington rates, and you're going to be paying 35% on that last $1 million. If you were to gift, well, I guess I should back that up. So it's 10 million that was taxable, so 10 million above the exemption. So if you were to gift that last $1 million, you would be saving essentially 35 cents on every dollar gifted. And so you'd save $350,000 by gifting it. So the cost of making the gift at the time of death versus making that gift even a few months earlier than that would be $350,000. Now, this is starting to say that we should also think about moving into other types of planning. It's really thinking about multi-generational planning. And this is really something that we see a lot with high net worth families and ultra high net worth families. Multi-generational planning is very common there. It is something that is done, and there's many structures that it's done in. But that's something that we can also learn from and then bring some of that to the states here in Washington that are subject to that. When I was thinking about multi-generational planning, I was thinking about the fact that many families are smaller, maybe than families of the 10 kids or 7 kids or 4 kids even. And how is this going to grow? What is that going to look like in the future? And one of the things I was thinking about was actually in the news today, where uh, Putin and Chairman Xi were meeting at were caught in a hot mic moment as they were watching the military parade there in China. And they were commenting about how by the end of this century, people will be living to 150 years. Could you imagine living to 150 years? I mean, that's quite the rise. But we have been seeing life expectancies of people who, are in their 70s and their 80s, and we can maybe expect them to live well into their 100s. And so it's not that far off that we could see that. Could you imagine, though, estate planning at the time of death for a 150-year-old, leaving their assets to their 120-year-old kids, or do they skip their kids and go to their 90-year-old grandkids, or do they skip them and go straight down to their great grandkids? And so increasingly, I think with longer lifespans, we should also think more about multi-generational planning. Okay, so here we're going to look at our Washington exemption planning with our foundation planning. This is really going to be looking at what we should do for married couples. Many of our clients are married couples, and so this would apply to their situation. Our primary goal with that is we want to make sure that we're using both exemptions. We don't have the ability to have portability at the state of Washington level. So that's going to be one of the first major changes between the federal system and the state of Washington system. At the state level, if you give all of your assets to your spouse at your death, your spouse will only have one coupon, one exemption available for them at the time of their death. Instead, at the federal level, you can do that, and there can be an election made for what's known as portability, and the surviving spouse could save or protect up to $30 million. So it's a very significant difference. And we're going to look at how we preserve both of those exemptions. We're also able to do separate state Q-tip elections, and this can be very powerful for doing a marital planning and for having the correct combination of federal and state exemptions. And as we see here, we can work both spouses together to get best use of those exemptions. So one of the key things we will look at is using a spousal exempt trust. The spousal exempt trust is a method of holding that $3 million at the first death. So in this example, what we're going to do is we're going to use a formula to divide the joint revocable living trust into 2 pieces at the time of the first death. The spousal exempt trust, which will hold up to $3 million from the deceased spouse's assets. That $3 million will be excluded from the estate of the surviving spouse at the time of the surviving spouse's death, and whatever growth happens on that will also be excluded from the survivor's estate. So if it grew to $6 million or $12 million, it wouldn't really matter. All of that would escape Washington state estate taxation. Now, the survivor's trust would be all of the survivor's property plus any amount above and beyond the amount that was going into the spousal exempt trust. But by using this method, we're able to protect the total of $6 million, using both exemptions. A couple of other things that we like to put in there is we do like to look at how we can use the federal Q-tip election. So essentially, we can use a federal toggle here, and the idea would be that we're able to put a federal Q-tip election onto the spousal exempt trust. This will permit us to get a step up in basis at the time of the surviving spouse's death. So it gets included in the surviving spouse's estate, and thereby reduces the capital gain exposure. And not only the capital gain exposure for the federal government, but also for the state of Washington and their capital gains tax. Additionally, Q-tip elections can be used for different purposes. And for example, in blended family situations, we may want to provide an amount that's going to be available to the surviving spouse for their life, but at their death, you may want it to go back to your children, for example. And so that's a very common use of what's been known as a marital trust. And we can, elect either to have federal or state Q-tip elections made to that. So that's one of our techniques also. Another strategy that we would include in our foundation planning is the opportunity to do gift later. So really when we're thinking about Washington state estate tax planning, we recognize that the tax won't be due until the time of the second death. And the tool we want to use to address that is the gifting. So our risk is that the surviving spouse may die prior to those gifts. And although we can't control that within our document, we can permit the use of gifting during their life, even if they're incapacitated. And so we want to include those types of provisions in the documents and plan that out. So one of the techniques that we're looking at here is how do we address this Washington state estate tax? Is there something new that we can do here that will find a way for us to really save additional Washington estate tax? Can we answer some of those questions and those concerns and those challenges that people have with the idea of gifting? To address this, we came up with 3 different types of gifting strategies using trusts. The first is what I've referred to as a flexible gift trust. The idea here is that you're pre-positioning assets to get them ready to be gifted and moved on to whomever your recipient will be. But if we're not quite ready to gift it yet, this allows for modifications to your gift or your distribution provisions. It allows you to change the assets that are in there up until the time that you want to make that gift happen. So those gifts could be sitting in that flexible gift trust. You could authorize the gifts to happen right away, little bits and pieces over time. You could also, if you became incapacitated, there could be provisions in there for that gifting to happen even if you're incapacitated. Also, it might happen that you get to a spot where you want it to just say, nope, I'm ready for it to go, and you could go ahead and convert it into a completed gift trust. The automatic gift trust is a variation on this, but it is an irrevocable trust to start with, and so we can't change the provisions in terms of it. However, because of the way that it's built here, it will be you'll have the power to really pull it back into your estate if needed, and so we can make some adjustments to it in that case. But we can also pre-program in when those gifts will happen, and so this can be a very satisfying tool to use. So, for example, we could reprogram it in so that if you became incapacitated, that gift would occur immediately. Or we could say when the beneficiary hits a certain age, or when you hit a certain age, or any other kind of criteria that we can define within the document. And that would convert the trust automatically into a completed gift trust and move those assets out of your estate. And finally, the irrevocable gift trusts, these are going to be a wide variety of different ways to do this. And we would be talking about, many of the types that we've thought about at the federal level for years. One that's very useful here in Washington State is a SLAT. And so we do have a follow on that later on how to use a SLAT. And a SLAT, if you're not familiar, is a spousal lifetime access trust. Now, in addition to the trust, the gifting trust we just went over, there's a number of other tools that have been used at the federal level that we can apply right back here into Washington State. The first one that I think of is really charitable planning. I love charitable planning. It's so useful in so many ways. We can use it to help address Washington capital gains tax. We can also use it to get a current income tax benefit, as well as, of course, fulfilling our charitable intent. So those are good ones to look at. Family limited liability companies is a different approach. I like this for multi-generational planning. It can be a way where we're building a structure that can be used really to train the next generation, and also to pass on assets in a way that will be asset protected from creditors or spouses. The father is to be a member of those family limited liability companies. So it can be a very useful tool for generational trust. You may have heard the BST trust. The purpose is really remove assets not only from the grantor, but also from the beneficiary. So with a multi-generational trust, we can avoid Washington estate tax for up to 150 years under Washington law. So that's a very significant amount of time. Some of the different types of trusts that we're going to be looking at are going to include how we have that trust income taxed. And so it could be taxed to the beneficiary, it could also be taxed to the trust, or it could be taxed to the grantor. But taxing it to the grantor can be a very effective way to move additional assets to get growth outside of the estate. And so it can be useful to have a toggle on that, where we can turn on and off that feature. Having it taxed to the grantor it can be a very good tool for reducing the estate, but it also means you're paying taxes for assets you're not enjoying. So let's look at the spousal lifetime access trust. So spousal lifetime access trust, you could move value into that trust for the benefit of your spouse, and it would be excluded from your estate and your spouse's estate for Washington estate tax purposes. Your spouse can actually be the trustee, can make investment decisions on that, and can receive income and principal for their needs without the involvement of a third party. If we do have a third party involved, it can be even more flexible than that. This type of planning could be used to move significant amounts of a married couple's assets into trusts for them, for each other. Theoretically, they could use their full exemption to do this, and so that would be their federal exemption. And so in theory, a married couple could protect $36 million from Washington estate tax and still maintain control and access by using these types of trusts. They are irrevocable trusts, and they are complicated tools, and so they do need to be looked at closely on how they're going to work. They're not necessarily for everyone, but they could be a fabulous tool in the right circumstances. So in addition to the slats, we might also consider, and I mentioned it earlier here, the charitable remainder trusts, the charitable lead annuity trusts, ILETs, irrevocable life insurance trusts. We also consider QBERTs are an example here. Any kind of gift trusts could be falling into that. Family limited liability companies, family limited liability partnerships. We can use this to create an estate freeze where the value that's inside the estate that's being taxed in your estate stays constant, but the growth is actually on the outside of your estate. It's in one of the different trusts, or it's in a limited liability company. Okay, so how can this planning work? Is this really all that valuable? I created a comparison here of an estate. So in this example, I'm starting with a married couple with $12 million of assets. They have a $6 million investment portfolio and $6 million of other assets that include their home. The investment portfolio is currently growing at 10% per year, and the other assets are growing at the rate of inflation, so they're not really growing significantly. What the plan here is to gift their portfolio assets into one or more slats that are outside of the Washington estate tax reach. The other $6 million will go ahead and just remain in their estate. So what we see here is the result of this kind of planning. First of all, with no planning, their estate would have about a $1.1 million Washington estate tax hit. 5 years from now, but with the planning, we were able to get rid of that hit entirely. 5 years from now, you can kind of see how those numbers are going up. Again, the blue line here is showing that by gifting that $6 million originally, there is no tax at the Washington state level. And that is because the assets that remain in the Washington estate are growing, but they're not growing faster than inflation. So that indexing is taking care of the potential tax there. But over the time here, our $12 million estate could end up being $51 million with that growth rates that we were looking at, and the estate tax savings from this plan could be $12.9 million. Okay, it's maintaining residence in Washington state. So our goal is to make it so that you don't have to leave the state of Washington due to this larger estate tax exemption, or excuse me, estate tax rates. Recall that currently, if your estate is $8.8 million or less, you're actually getting a tax cut. You're not getting a tax increase. So don't be packing your bags yet. For those estates that are above that and you are seeing Washington estate tax, there's planning that we can do. Let's make sure we're utilizing both of those exemptions. Let's look at the kind of gifting we can do. Let's use some of these strategies and get started with some of that. And let's think about whether a slat makes sense or one of the different types of gift trusts that we've considered here and created for this purpose. Now, we've gone ahead and created a Washington state estate tax calculator to help with this, and I wanted to give you a little bit of information on that if you haven't had an opportunity yet. This Washington state estate tax calculator we have over at the Washington estatetetax.com website, and you're welcome to use that at any time, and you can calculate your own tax liability using that.